Assalamualaikum and hi. Today, we want to present about our assignment topic is express condition. Before we start our presentation, let me introduce my team members, which is Aslam Syahiran, Fatin Nurul Musyazana, Wan Ainur Arisha, Nur Alia Nadira, and myself Hakimi Farhan.
Introduction. Our group has been decided to choose express condition from the topic. In legal context, condition or requirements that must be satisfied. Express conditions are dues that are clearly and specifically articulated by the parties involved in a contract or legal agreement. For the court case that we choose for this topic is Majlis Perbandaran Subang Jaya versus Visa Maya, SDN BHT and ANOR. Definition of express condition. Express conditions are specific terms or obligation explicitly stated in a contract. They set clear standards or requirements that must be met to trigger the contract's consequences, rights or duties, ensuring clarity and responsibility for all parties involved. An express condition requires a specific event to occur before a party is obligated to fulfill their contractual duties. If the condition isn't met, the party isn't legally bound to perform. There are two types of express condition, which is condition precedence and condition subsequent. State authorities determine conditions at the time of alienation, which must be endorsed on the title document. These conditions may require continuous performance or be subject to a fixed term binding the land or proprietor. If they conflict with local bylaws, the condition prevail. Every condition or restriction begins from the date of alienation.
Parties involved. There are three parties involved in this court case. The first respondent who was appealed the case into High Court to build two blocks was rejected by the appellant because the project was not suitable and the only commercial building allowed to do. None of the parties is not rational in this case. First, Majlis Perbandaran Subang Jaya, the appellant, MPSJ, known as the City Council, which is in charge of the Subang Jaya City and the southern parts of Petaling District. This is under Selangor State Government of Malaysia. MBSJ are responsible for the public health and sanitation, waste removal and management, town planning, environmental protection and building control, social and economic development. Second, Visa Maya Sdn Bhd, the first respondent. Visa Maya Sdn Bhd is a real estate company located in Kuala Lumpur, Malaysia. The company that involved in property investment and development. The company was registered in 25 June 2010. And the last party involved is Appeal Board, the second respondent.
Facts of the case. According to the court case, Majlis Perbandaran Subang Jaya was the plaintiff in this case of the express condition, while Visa Maya Sdn Bhd and ANOR was the defendant of this case. The plaintiff, Majlis Perbandaran Subang Jaya, is the local planning authority for a plot of land called Lot 847. Lot 847 is located within the jurisdiction of the plaintiff and has a freehold title with the category of land use stated as industrial and an express condition for medium-scale industry. The plaintiff received an application from the registered owner of Lot 847 to convert the land's use category to building and the express condition to industrial. The plaintiff notified that it had no objection to the change of use to commercial, and the state authority approved the conversion of the land use category to building with the express condition of commercial building. The first respondent, Visa Maya Sdn Bhd and ANOR, applied to the plaintiff for planning permission to build two blocks of commercial service apartments on Lot 847. The plaintiff rejected the application, stating that the proposed project was inconsistent with the surrounding land usage and that only commercial activity supporting the existing industrial area could be permitted. Visa Maya Sdn Bhd and ANOR appealed to the appeal board against the plaintiff's decision, but the appeal was dismissed. The first respondent obtained an order from the High Court to quash the decision of the appeal board and a mandamus to reconsider the appeal. The plaintiff appealed to the Court of Appeal.
Plaintiff arguments. In the case of Majlis Perbandaran Subang Jaya versus Visa Maya Sdn Bhd and ANOR, Majlis Perbandaran Subang Jaya argued against Visa Maya Sdn Bhd and ANOR regarding the planning permission for the construction of two blocks of commercial service apartments on a specific piece of land. Majlis Perbandaran Subang Jaya contended that the proposed construction was inconsistent with the surrounding industrial land usage and therefore not in compliance with the relevant laws and regulations governing land use and planning permission. This indicates that Majlis Perbandaran Subang Jaya sought to uphold the existing land use regulations and ensure that any proposed development was in line with the surrounding areas, zoning and land use plans as per the local authorities' responsibilities. This is important because local authorities have a responsibility to ensure that any proposed development is in line with the local area's zoning and land use plans, which are designed to promote sustainable development and protect the environment. By upholding these regulations, Majlis Perbandaran Subang Jaya was able to ensure that any proposed development would not have a negative impact on the surrounding area and would be in line with the local community's needs and expectations. Defendant's argument. In the response to the plaintiff's claim in Majlis Perbandaran Subang Jaya versus Visamaya Sendirian Berhad and Anor, the defendants, Visamaya Sendirian Berhad and Anor, presented the following arguments. First, invalidity of TCPA and zoning laws. The defendants contended that the Town and Country Planning Act of 1976 and its associated zoning regulations were incompatible with the land use definitions outlined in the National Land Code. They asserted that the National Land Code should take precedence, and as a result, the TCPA and zoning laws should be considered invalid. Unenforceability of MPSJ local plan restrictions. Visamaya Sendirian Berhad and Anor argued that the MPSJ local plan, specifically the restrictions it placed on the use of Lot 847, should be regarded as a restriction under Section 108 of the National Land Code. However, they contended that this restriction should be deemed unenforceable due to their conflict with the explicit clauses in the Lands Register document of title. Third, statute interpretation and purposive interpretation. The defendants brought up the matter of statute interpretation and purposive interpretation. They argued that the High Court should consider the conflict between the National Land Code and any limitation imposed by the local government or planning authorities. This suggests that the defendants believe that the court should take into account the broader context and purpose of the laws in question.
Court decision. In the case of Majlis Perbandaran Subang Jaya versus Visamaya Sendirian Berhad and Anor, the court rendered a decision to allow the appeal overturning the High Court's previous ruling. The court specifically addressed the contention that Section 108 of the National Land Code rendered the Town and Country Planning Act 1976 and its associated zoning inconsistent with land use under the NLC title, deeming the submission null and void. The court emphasized a harmonious interpretation of the NLC and the Town and Country Planning Act 1976. According to the court, any potential inconsistency should be resolved in favor of the TCPA as the latter legislation, thereby asserting its precedence over conflicting provisions in the NLC. In light of this interpretation, the court concluded that the local planning authority's decision to reject the application for planning permission was deemed valid. This decision reflects the court's perspective on the interplay between the NLC and TCPA, ultimately favoring the latter in the event of any inconsistencies. Conclusion. Majlis Perbandaran Subang Jaya versus Visamaya Sendirian Berhad and Anor was the express condition stated in the register document of title should be construed as a restriction imposed by the local authority or planning authority upon the owner of the land. If the restriction is inconsistent with the express condition in the register document of title, the restriction shall not have any effect. In detail, the case involved an application for planning permission by Visamaya Sendirian Berhad to build a commercial building on a piece of land in Petaling Jaya, Malaysia. The local authority rejected the application, citing a breach of planning regulations. Visamaya Sendirian Berhad appealed the decision to the appeal board, which also rejected the application.
However, the Court of Appeal disagreed with the High Court's interpretation of the relationship between the NLC and TCPA. The court held that the submission that Section 108 of the NLC rendered the TCPA and zoning thereunder to be inconsistent with land use under the NLC title was null and void and held no merit. The court found no illegality, procedural impropriety, irrationality, or lack of proportionality in the decision of the appellant and the appeal board. Therefore, the court allowed the appeal, set aside the order of the High Court, fixed costs in the sum of Rm 20,000 here and below, and ordered the deposit to be refunded. The implications of this case for property owners seeking planning permission in Malaysia are that the NLC and TCPA should be read consistently, and if that is not possible, the TCPA as the later legislation prevails.